Hi, this is your friend Soumya, and today we're going to learn about Communications Decency Act. Section 230 of the Communication Decency Act, 47 U.S.C. 230, a provision at the Communication Decency Act tucked inside the Communication Decency Act (CDA) of 1996 is one of the most valuable tools for protecting freedom of expression and innovation on the Internet. Section 230. This comes somewhat as a surprise, since the original purpose of the legislation was to restrict free speech on the Internet. The Internet community as a whole objected strongly to the Communications Decency Act, and with the EFFS helps, the anti-free speech provision was struck down by the Supreme Court. But thankfully, CDA 230 remains, and in the years since has far outshone the rest of the law. Section 230 says that no provider or user of an interactive computer service shall be treated as a publisher or speaker of any information provided by another information content provider. In other words, online intermediaries that host or republish speech are protected against a range of laws that might otherwise be used to hold them legally responsible for what others say or do. The protected intermediaries include not only regular internet services providers but also a range of interactive computer service providers, including basically any online service that publishes third-party content. Though there are important exceptions for certain criminal and intellectual property-based claims, CDA 230 creates a broad protection that has allowed innovation and free speech online to flourish. This legal and policy framework has allowed for YouTube and Vimeo users to upload their own videos, Amazon and Yelp to offer countless user reviews, and Craigslist to host classified ads, and Facebook and Twitter to offer social networking to hundreds and millions of internet users. Given the sheer size of user-generated website, for example, Facebook alone has more than 1 billion users, and YouTube has uploaded 100 hours of video every minute, it would be infeasible for online intermediaries to prevent objectionable content from cropping up on their site, rather than face potential liability for their users' action. Most would likely not post any user content at all, or would need to protect themselves by being actively engaged in censoring what we say, what we see, and what we do online. In short, CDA 230 is perhaps the most influential law to protect the kind of innovation that has allowed the Internet to thrive since 1996. Thank you.